Welcome back to the deep dive. Today we're tackling a really serious, necessary topic, South Africa's big legal response to human trafficking.
That's right. We're digging into the Prevention and Combating of Trafficking in Persons Act, or PACTIPA. It's a major piece of legislation, and it just got an update, actually, on October 11th, 2024.
Yeah, and our goal here really is to cut through all the legal jargon.
Right.
Whether you're maybe a law student needing the nitty-gritty or just an informed citizen who wants to understand what's going on.
Exactly. This deep dive is kind of your shortcut to understanding this consolidated act, its core ideas, and why it's actually quite revolutionary in its approach.
So before we get into the details, maybe why was this act even needed? What was wrong before?
Well, that's crucial context. If you look at the preamble of the act itself, it spells it out pretty clearly. Before 2013, South Africa's existing laws and the common law, other statutes, they just weren't equipped.
Not equipped how?
They couldn't really deal with the organized, systematic nature of modern trafficking. The legal tools are just too fragmented. It wasn't working.
Okay, so PACTIPA came in to consolidate things.
Precisely. It pulled everything together. And importantly, it gives legal force to South Africa's international promises, like the UN's Palermo Protocol on trafficking.
But it's not just about international law, right? It connects back to South Africa's own foundation.
Absolutely. It's deeply rooted in the Constitution. It's about upholding fundamental rights, human dignity, equality, and critically, freedom from slavery, servitude, forced labor, all of that.
So if you had to boil it down, what are the main goals of this act, the why behind it?
Section 3 lays out four main pillars, basically. First, punish offenders properly with serious penalties.
Right.
Second, actively work to prevent trafficking in the first place. Third, make sure victims get protection and real assistance.
And the fourth?
And finally, and this is a big one, ensure coordinated implementation across government. Getting everyone working together. That coordination piece is, well, it's ambitious but vital.
Right. That sounds like a challenge in itself. Okay, let's dive into the core of it, the actual crime. When the law says trafficking in persons, what exactly does that mean? What are the components?
You can think of it in three parts: the act, the means, and the goal.
Act means goal.
Okay, what's the act?
The act is the physical doing part, delivering, recruiting, transporting someone, selling, exchanging, leasing, even just receiving a person. It covers moving people across borders, sure, but also just within the country.
So pretty broad actions. What about the means? How is this done?
This is where it gets really comprehensive. The law recognizes that trafficking often isn't just about brute force, though that's included. It's often about control, manipulation.
Makes sense.
So the Act lists 9 specific methods, things like threats of harm, actual force, abduction, kidnapping, but also fraud, deception, abusing a position of power.
Okay, so subtler methods too.
Yes, and critically, it includes giving or receiving payments or other benefits to get control over someone. This often involves targeting, say, a parent or guardian to get access to the actual victim. Right, paying off someone to get to someone else.
Exactly. And all of this, the act and the means, has to be done for a specific goal.
Which is?
Any form or manner of exploitation. And this is where the law really shows its scope, going beyond what maybe people typically think of trafficking.
Okay, so what counts as exploitation under this act?
Well, it includes the things you might expect, like sexual exploitation, forced labor, servitude. But it goes further.
How so?
It specifically includes the involuntary removal of body parts, organs, tissues, and it even addresses the incredibly specific and horrific act of impregnating a woman against her will, just to sell her child after birth.
Wow. That clause about selling the child is incredibly stark. It shows the law is trying to cover any situation where a human life is just treated as a commodity.
It really does. But here's a concept that I think really transforms how we understand the means used in trafficking. Abuse of vulnerability.
Abuse of vulnerability. Okay, what does that mean legally? Is it like punishing someone for taking advantage of desperation?
That's a pretty good way to put it, yeah. The Act defines it as any abuse that makes a person feel they have absolutely no reasonable choice but to submit to the exploitation.
And does it give examples?
Yes, and this is key. It lists specific vulnerabilities. Things like being a child, having a disability, being pregnant, or struggling with addiction.
Yeah.
Those are maybe more personal factors.
Okay.
But crucially, it also includes wider societal or structural vulnerabilities.
Like what?
Like having an illegal immigration status in South Africa, or being in really difficult social or economic circumstances, basically, poverty or extreme hardship.
So the law is actually saying that if a trafficker uses someone's poverty or their fear of deportation against them, that's legally the same kind of coercion as, say, a physical threat.
Exactly.
Mm.
It recognizes that exploiting that kind of pre-existing power imbalance, often caused by systemic issues, is a criminal means of control. It really broadens the whole picture of coercion.
That feels like a major shift. Legally and maybe even morally, it widens the net considerably.
It does. And speaking of widening the net, Chapter 2 of the Act details related offenses. It shows they're trying to capture the whole trafficking enterprise, not just the person doing the transporting.
Right, not just the kingpin, but the whole network. What kind of related crimes are we talking about?
Things like debt bondage, where
Right.
someone is forced to work off a debt that's, clearly unreasonable, or the terms are completely
A
undefined.
classic tool of control.
Definitely. And also, document offenses intentionally destroying, hiding, or tampering with a victim's ID documents. Another classic tactic to keep someone trapped.
Okay.
Yeah.
But you mentioned earlier something about liability for people who benefit from trafficking, even if they aren't the traffickers themselves.
Yes, this is Section 7, using the services of a victim of trafficking. And this is where it gets potentially challenging for businesses and even the general public.
How so? What's standard?
It's an offense if you benefit, financially or otherwise, from a victim's services, and you knew, or here's the key part, ought reasonably to have known or suspected that the person providing the service was a victim.
Ought reasonably to have known. That sounds like it imposes a duty to be aware, doesn't it? You can't just plead ignorance.
Precisely. It introduces a standard of due diligence. What would a reasonable, vigilant person in that situation have known or suspected? It means you can't just turn a blind eye if the warning signs are there.
Can you give an example? Maybe for a business?
Sure. Think about, say, a small hotel or a guest house owner. If they consistently rent rooms, maybe cash only, to someone who brings in groups of young people who look distressed, have no papers, seem controlled,
Yeah.
if the circumstances would make a reasonable person suspect trafficking, and the owner continues to lease the property facilitating it, they could be liable under Section 8 for facilitating conduct, or potentially Section 7 if they benefit.
Okay, that makes sense. And this applies to transport companies, too. Carriers.
Yes, Section 9 specifically deals with carriers. It's an offense for, say, a bus company or even a private taxi driver to transport someone if they knew or, again, ought reasonably to have known they were a victim.
And the consequences for them.
Beyond the criminal penalty, there's a significant financial liability. A carrier found guilty under this section can be ordered to pay for the victim's recovery costs,
Recovery costs, like what?
like their care, accommodation, transport back home, even repatriation expenses if they're foreign.
Mm-hmm.
The law basically says if you facilitated this through negligence or knowledge, you help pay to fix the harm.
That's a powerful incentive for due diligence. Now, what about defenses? Can a trafficker argue the victim agreed to it, especially in cases involving, say, sexual exploitation or labor?
This is absolutely critical. Section 11 deals with the no consent defense, or rather, the lack of it.
How does it work?
For a child victim, anyone under 18 consent is never defense, period. Even if the traffickers use zero coercion, zero threats, the law states clearly, a child cannot legally consent to their own exploitation, full stop.
Okay, crystal clear for children. What about adult victims?
For adults, consent is also not a valid defense if any of those coercive means we talked about were used.
So if there was fraud, deception, threats, or that abusive vulnerability.
Exactly. If any of those were present, the traffickers can't just say, oh, but they agreed to it. That agreement was obtained illegitimately through coercion, so it's legally meaningless as a defense.
Right. And the penalties, if someone is convicted, are they substantial?
Oh, yes. The Act has real teeth. For the main trafficking offense under Section 4, the penalties can go up to a fine of R$100 million or life imprisonment, or both.
Life imprisonment. That's serious.
It is. And even for those related offenses like debt bondage or using a victim's services, you're looking at potential sentences of up to 15 years. It sends a strong message.
Does it only apply to crimes within South Africa?
No, it actually has extraterritorial jurisdiction under Section 12. If a South African citizen or resident commits trafficking outside the country, they can still be prosecuted in South African courts if they return or are found here and aren't extradited.
So it closes that loophole. Okay, let's shift focus a bit. The Act isn't just about punishment. You said it's also about victims. What does it do for them? Starting with identifying them.
A key part is mandatory reporting, covered in Chapter 4. This puts a duty on everyone.
Everyone.
Pretty much. Any person, doesn't matter if it's a neighbor, teacher, doctor, whoever, who knows, or, again, ought reasonably to have known or suspected that someone, child or adult, is a victim of trafficking, has a legal duty to report it immediately to the police.
But if they don't?
Failure to report is actually an offense itself. The only main exception carved out is for information protected by legal professional privilege, between a lawyer and their client.
Wow. So a broad duty to report. What happens once a potential victim, maybe a foreigner, is identified?
For foreign nationals who might be victims, there's a really important provision: the recovery and reflection period under Section 15.
Recovery and reflection, what does that involve?
If a foreign national is identified as a potential victim, especially one who might help with an investigation, they can be issued a temporary visitor's visa for up to 3 months.
3 months. What's the purpose of that time?
It's specifically for recovery and reflection. It gives them a breathing space. They can access accredited support programs, get help, and importantly, decide if they want to cooperate with law enforcement without the immediate threat of deportation hanging over them.
So they can't be deported while this is being decided or during this period?
Correct. They're protected from deportation while the decision about this status is pending and during the period itself. It's vital for building trust and allowing victims to regain some agency.
That seems crucial for actually getting justice. Does the Act consider situations where victims might have been forced to commit crimes themselves?
Yes. Section 22 addresses this directly. It mandates prosecutors to specifically consider whether any offense committed by the victim, maybe immigration offenses, petty theft, drug use forced on them, was a direct result of them being trafficked.
And if it was?
If they get formal recognition as a victim through a letter from the authorities, that can be grounds for the prosecutor to actually withdraw the charges against them. It recognizes they weren't acting with criminal intent, but under duress.
That's a really important protection. What about ongoing support?
Chapter 5 sets up the framework for victim support. It requires the government to accredit organizations, NGOs, shelters to provide essential services, things like safe accommodation, counseling, healthcare, help with reintegration into society. And there are norms and standards these places have to meet, focusing on safety, confidentiality, proper care. And finally, on the justice side for victims, the courts have the power, under Section 29, to order a convicted trafficker to pay compensation directly to the victim.
Compensation for what?
For harm suffered. Things like lost property, physical or psychological injuries, even compensation if they contracted a life-threatening disease like HIV as a result, or for lost income or support. It tries to provide some financial redress.
Yeah, repatriation if they're foreign. Is that handled carefully?
Very carefully, according to Section 31. For child victims, any decision about sending them back must prioritize their best interests, their safety, and whether there's suitable care available back home. For adults, their safety must be considered before repatriation happens. It's not just automatic deportation.
Okay, so it seems like a really comprehensive approach to victim support and protection. Now, you mentioned coordination earlier as a key pillar. How does the Act try to make that happen? That sounds like the really difficult part.
It is difficult, and that's why Part 4 on coordinated implementation is so critical. Trafficking isn't just a police issue or an immigration issue. It cuts across everything.
Right.
So the Act mandates a national policy framework, detailed in Section 40 and 41. This legally requires cooperation between, well, almost a dozen different government ministers and their directors general. We're talking justice, home affairs, police, social development, health, international relations. The list goes on.
It forces them to work together.
It legally requires them to. It recognizes that working in silos just doesn't work for combating trafficking. You need an integrated response.
And how do they integrate? Is there a mechanism?
A key mechanism is data. Section 41 mandates the Director General of Justice to set up and manage an integrated information system. This isn't just record keeping. It's designed as an analytical tool.
Analytical tool. What kind of data does it track?
Really specific, granular data points needed to understand the trafficking patterns. Things like where are victims coming from? Where are they being taken? What routes are traffickers using, both inside South Africa and across borders?
So mapping the logistics.
Exactly. And also detailed profiles, age, gender, nationality of both the victims and the traffickers. The goal is to see the bigger picture.
How does mapping routes and profiles help?
By connecting all these dots, the system aims to identify links. Links between seemingly isolated local trafficking cases and larger, potentially transnational organized crime networks. It allows for more strategic, proactive interventions, not just reacting after the fact.
Trying to disrupt the networks before they exploit more people.
That's the idea. And supporting this proactive approach, the Act also mandates specialized training, Section 44 talks about this, for police, prosecutors, and others involved.
Training on what?
On how to handle these cases properly, effectively, efficiently, but also sensitively, recognizing the trauma involved. Plus, public awareness campaigns to help people recognize and report trafficking. It all ties back to prevention and protection.
Okay, so bringing it all together, what's the big takeaway here? What does this act really achieve?
Well, it's a huge step forward. It took a jumble of inadequate laws and created a single, powerful framework. It's punitive for offenders, yes, but it's also administrative, coordinating government action, and deeply focused on restoring victims.
And that focus on vulnerability seems key.
I think that's the most revolutionary part. By making the exploitation of vulnerability, poverty, addiction, immigration status a core part of the crime, it forces the legal system, and maybe society, to look beyond just physical violence. It acknowledges these deeper systemic issues that traffickers prey on.
So, for this whole system to really work, it's not just about catching traffickers.
Oh, no. The enforcement side police, courts has to consistently recognize and prioritize these complex human factors that the law now acknowledges. It's about addressing the circumstances that make people vulnerable in the first place, not just punishing the criminals who exploit those circumstances.
That leads to a final thought, then. This act demands this huge, coordinated effort across government built around mapping and understanding vulnerability through data. So beyond just counting arrests or convictions, what other kinds of metrics would really show if this national policy framework is truly succeeding in preventing trafficking?
That's the million-dollar question, isn't it? If the system is truly mapping vulnerability, maybe success looks like seeing measurable reductions in the types of exploitation linked to things like economic distress or illegal status. Tracking those underlying factors might be the real test of whether this comprehensive approach is making a difference long-term.
Something to definitely think about, a complex challenge embedded right within this ambitious law.